as per the manner specified by its regulations. Further, Chamber of Arbitration has also been established to impanel arbitrators, both domestic and international, as per the empanelment regulations.
The establishment of the India International Arbitration Centre marks a significant milestone in India's pursuit of global recognition as a prominent player in the field of arbitration. This will not only affirm the nation's standing in the international arbitration community, albeit IIAC as an institution will foster a sense of trust and credibility among both domestic and international parties engaging in arbitration within India. I hope the IIAC will emerge as a credible frontline institution in providing a dedicated and specialized platform for arbitration and will enhance the accessibility and efficiency of dispute resolution in India.
Debates about streamlining the process of commercial disputes have been going on in India for quite some time. And the intense international competition among nations to prefer their own centers of international arbitration was another subject. But now India has launched a major initiative taking stock of both these aspects.
The India International Arbitration Centre is managed by a team of eminent persons having substantial knowledge and experience in institutional arbitration at both domestic and international level. The Chamber of Arbitration will impanel arbitrators from amongst the persons who are proficient and willing to serve as arbitrators based on their expertise and experience. The panel of arbitrators includes both experienced as well as young professionals. The Centre has an efficient secretariat to administer arbitration under a progressive set of the conduct of arbitration regulations.
There has been a paradigm shift in the traditional mindset of ADR mechanism, especially in the arbitrations. And when we talk about institutional arbitrations, IIAC has indeed taken the front lead at the national level.
The vision of India International Arbitration Centre is to promote the overall alternative dispute resolution mechanism from the grassroots level with an aim to lessen the burden of courts to the extent possible.
In arbitration, institutional arbitration has definite advantages. All over the world, institutional arbitration has attained such great heights, especially in London, Singapore, Hong Kong, and other places. In India, we have institutions which are at Mumbai, Chennai, and other places. But at the central level, to have an institution as a flagship institution is what is this India Arbitration International Centre. The Parliament is conscious of the fact that India has to be, with the growth on economic front that we are achieving, consistent with that, the commercial disputes also need to be resolved at an early date, expeditiously, and with element of certainty and consistency.
India is marching towards autonomous, independent institutional arbitration regime. I welcome you to India International Arbitration Centre, where disputes find resolution.
A very good afternoon, everyone. A warm welcome to all those present here in person and also to all who are joining virtually. The India International Arbitration Centre, established under the IAC Act 2019, embodies the vision of creating an autonomous world-class institution for administrating arbitration and other forms of ADR. Today's gathering brings together distinguished members of the legal fraternity, academia, students, and all those who contribute to and engage with the evolving landscape of arbitration and alternative dispute resolution. This afternoon provides us an opportunity not only to share insights and perspectives, but also to strengthen the collaborative fabric that supports the growth of ADR in India. With that spirit, we begin with our panel discussion on the theme Confidentiality, Cyber Risk, Data Laws, and Privacy Compliances in Modern Arbitration. As arbitration increasingly intersects with technology, this topic remains central to maintaining trust and integrity in the arbitral process. Now I invite our moderator for this panel discussion, Mr. Kanu Agarwal to the stage. Mr. Agarwal is an advocate on record at the Supreme Court of India, known for his role in landmark constitutional matters and his representation of major public institutions, including the Union of India, several state governments, and many PSUs. He has represented numerous key agencies, including the CBI, ED, and SFIU, in high value disputes. He serves as retainer counsel for BCCI and is widely regarded for his expertise in complex constitutional, regulatory, and commercial litigation. Now I invite Dr. Nidhi Gupta to the stage. Dr. Gupta is an associate professor at NLU Delhi with over 2 decades of experience in legal education, judicial training, and international research in arbitration and private international law. She has taught and published extensively in India and Europe, and previously served as executive director of the Center for Advanced Research and Training in Arbitration Laws and faculty advisor to the Indian Journal of Arbitration Law. Now I invite Ms. Abhisar Bairagi to the stage, please. Ms. Bairagi is a partner in dispute resolution practice at Khaitan and Company, representing India and international clients in commercial and infrastructure related arbitrations. Her practice spans mediation, pre-dispute strategy, and arbitration across sectors, including logistics, mining, energy, transportation, and warehousing. Now I invite Mr. Dhirendra Negi to the stage. Mr. Negi is a leading disputes lawyer with 3 decades of experience in complex commercial and corporate disputes and a partner at JSA. He has acted in over 75 high-stakes arbitrations with an exceptional success rate and regularly advises on major construction, engineering, oil and gas, and technology disputes. Now I invite Mr. Dinesh Pardasani to the stage. Mr. Pardasani is a partner at DSK Legal with over 20 years of experience across international and domestic arbitrations, appearing before Supreme Court, High Court tribunals, and regulatory bodies. He has led major disputes across railways, power, airports, and infrastructure, and is ranked across multiple global legal directories for his excellence in arbitration and energy law. With the panel now convened, may I request Mr. Agarwal to take the floor and lead the discussion.
Privacy, how its intersection has become important in modern arbitration. I believe this.
It's a great honor and privilege to be invited by the Indian International Arbitration Center. The topic for today's discussion is extremely important. And the advancement of modern technology, the rise of artificial intelligence, the ability of global tech companies to mine metadata, profile individuals and corporations alike, and the intersection of all these aspects with modern arbitration is something that we will discuss. Confidentiality and privacy, which were the cornerstone of arbitration and which were the reason behind arbitration being chosen by private parties as the alternate dispute resolution, are under serious threat. With the Puttaswamy judgment, the Supreme Court by 9 judges declares privacy as a fundamental right, but that declaration only carries us thus far. The ability to enforce that declaration, the ability to ensure that the rights of privacy and confidentiality are carried forward in our lives, in our dispute resolution, is through a structural framework that the government is to provide and that the parties have to develop themselves. To discuss these aspects, we are here with an extremely illustrious panel. Since the introductions are already done, I'd straight away go to the subject. And my first question will be to Nidhiji. Nidhiji, as far as confidentiality in arbitration is concerned, can you tell us what is the present regulatory framework? What is the statutory and the regulatory framework concerning confidentiality in arbitration? And what are the responsibilities that this framework places on various stakeholders?
Thank you. Thanks, Kanu. Yeah, as Kanu said, it's an honor to be invited here. I'm really thankful to Justice Gupta and Vinodji for thinking of me as an academician to be here, because arbitration and dispute resolution is so much a practitioner's word. So it's really nice to bring in this perspective also. Now, coming directly to confidentiality, as Kanu said, if I can use these words, arbitration and confidentiality are strange bedfellows, in the sense that arbitration is there because of one of the important reasons for arbitration is privacy and confidentiality. So arbitration is supposed to be offering all the in terms of third-party adjudication, but taking away all the disadvantages of litigation, like procedural inflexibility and washing your dirty litigation makes you do. So arbitration in that sense was supposed to be confidential. And we look more into global scenario. Internationally, it has been very difficult to think even how to regulate it. So it has been thought, yeah, confidentiality goes hand in hand with arbitration. It's like taken for granted that it has to be there in arbitration. But how do we ensure it? How do we protect it when parties themselves are not coming forward to? So it's like enforcing ethics. So enforcing confidentiality is as difficult as, it's like very difficult to enforce. Jurisdictions have confidentiality as a statutory provision. So in India, we adopted it in 2019 as a statutory provision, but it came with its own challenges, it came with its own problems, because it was included in continuation with recommendation made by Justice Shri P. N. Shri Krishna Committee, HLC. Confidentiality. And that's what became problematic, that even rights, more important for fundamental rights are the limitations. So what is more important?
Thank you, Nidhi, for shedding this light as a starter on the issue of confidentiality. Us on the global position on confidentiality in arbitration.
Read it into their Arbitration Act. There is no
ये ऑडियो वाला दिक्कत कर रहा है, ऑडियो नहीं हो रहा भाई.
available. If you look at it takes into account, especially Hong Kong takes into account everybody, not only the parties and the arbitrator and the institutions, but it also takes into account cloud service providers, transcribers, expert witnesses, who are the people who are working with the expert witnesses. So it's very comprehensive, and not only do they cover the arbitration proceedings, the arbitration itself, the arbitration award, so everything is covered. Something like France, which says domestic arbitrations, yes, there's a confidentiality clause in their law which covers it. For non-domestic, they say. I'd say somewhere lies in the middle, and what Nidhi was talking about. So basically, we have it. It covers the arbitrators, it covers the parties, it covers the institutions, but it probably has not caught up with the times that we live in, because what about cloud service providers? What about third-party transcribers? What about people who are keeping your records in e-form or another form? So I think that's where we lie on the spectrum, somewhere in the middle.
Thank you, Nidhi. In fact, this thank you, Abhisar. In fact, this leads me to a question, and if I can ask both the panelists at this juncture, is that the people who handle the data and the servers where it is kept, can there be some best practices with regard to that, especially concerning the audience today, considering that we are at a particular arbitration center? Is it possible for arbitration centers or bodies providing institutional arbitration to have their own servers, so that parties have more confidence in terms of where their meetings and where their documents are going?
See, one thing that I could think of is, and my technological prowess leaves a lot to be desired level. But one thing that I could tell you is that probably when we have the first meeting, CMCs, and all institutions have their own rules as to how they give out the first order, the practice orders. So maybe they could contain a clause, or maybe they could contain some kind of a declaration as to who all would be accessing it, and how all would it be accessed, who all would be storing it, after how long would the data be deleted, and how long will it be retained. And that's just one thing that I can think of that the institutions could do.
If I may just add.
Just to add here, because in India we have a lot of ad hoc arbitration also. So when we talk about maybe like we can impose this kind of obligation on the institutions to have their own server. But what do we do with ad hoc arbitration? Because in India ad hoc arbitration is also existing side by side with institutional arbitrations. That remains a challenge.
If I may just add, and that is the reason Justice Gupta mentioned about arbitral institutions. So we need to move on from ad hoc to arbitral institutions, and institutions like ICC and AAA, American, they have their own servers where they are now, as going forward, they're expecting all parties to submit their documents on this one server, and only these stakeholders can access that information and nobody else. So that's a way to keep that privacy, to answer your question.
Certainly. Moving ahead, Dhirenji, can you tell us how does the statutory provision tackle these modern challenges in terms of confidentiality?
Yeah, good afternoon, everybody. And I thank IIC, Justice Gupta, and others for having invited all of us on this panel, and we are really grateful for that. Coming to your question, see, before we get into the sufficiency, there are two aspects we need to look into so far as the confidentiality is concerned. First is the level of the agreement between the parties, right? Now, this agreement can be in the commercial agreement between the parties, or it could be in the rules which the parties have chosen, the rules which will conduct the arbitration process. Now, so far as the agreement is concerned, then it binds the parties and it becomes enforceable. So any breach of a confidentiality provision dehodes that agreement can be enforced. And in fact, if I'm not wrong, the IIAC rules expressly have this provision of giving the authority to the arbitral tribunal to sanction the parties if in case there is a breach of the confidentiality provisions. The other, now that is at the agreement level. Now if you come to the second level, at the statute level, now Nidhi and Avisar have already pointed out that we have section 42A in our Arbitration Act. But I think that provision could be, or rather it needs to be strengthened a lot, because as Abhisar already pointed out, it is not just the parties and the arbitrators or the tribunal or the institutions which are involved in the arbitration process. There are several persons who are there in the periphery, who are the service providers, be it the experts, be it the cloud service provider, the email service provider. There are a number of persons who are like on the periphery, but they're involved in the arbitration process. Now, how do you control that? How do you supervise these people? And how do you make them accountable? Because they're outside the purview of the agreement. So, how do you make them? I think that's where the law should step in. And this provision under section 42A should be strengthened more. It needs to be clear as to how it will hold accountable these persons, including the parties, of course, and what are the sanctions which will be imposed in case there is a breach of this statutory obligation as compared to the obligation taken upon by the parties through an agreement. So I think there is a lot of thought needs to be given there.
I think that's a very important point as to how there are other stakeholders to the entire process and how we can bind them through confidentiality norms. Taking cue from that, Dineshji, can you tell us, apart from the legislative measures, what best practices can institutions adopt or parties adopt in order to maintain confidentiality?
Yeah, so one, before I come to ways and means. Thank you. So, before coming to what are the ways and means to ensure confidentiality beyond the statutory provisions, I think before that, statutory provisions have to be liberally interpreted. In a matter, because the reference under section 42A is referring to arbitral institution, arbitrators, and parties. It does not include lawyers. So there was an argument made that it's not applicable to lawyers. But of course, the arbitral tribunal held that counsels representing parties will be included within the definition of parties, but it has to be liberally interpreted. Second, until, as Devendra mentioned about modifications being done, I think Abhiraj, mentioned that during the CMC proceedings, in the procedural order, you need to mention if your matter is really confidential and requires that complete secrecy has to be maintained, then procedural order should set out maybe the data has to be stored on a particular website where only those stakeholders will have access to. Even in section 9 and 11, I think it should be allowed where parties can redact the names of the parties and they just go with, as Singapore goes, you mention XYZ versus ABC. So you complete secrecy is kept. You in fact can redact the contract and the terms, the financial
confidentiality is maintained. Similarly, even when the matter goes for, say, Section 34 or Section 9, you can always make a request that, look, because we have gone for arbitration and we want to keep it complete confidential, there should be chamber hearing. You know, there have been instances in Singapore where these specific requests have been made that because we have gone for arbitration and we want to keep complete secrecy about it, the courts have held these hearings in chambers. Similarly, even when awards are passed and Section 34s are filed, you can always redact those awards. I think the challenges that we are coming across are obviously changing day-to-day basis because of various breaches that we'll be talking about as we go forward. But I think these are the 2 or 3 instances that I can think that can be implemented to ensure, you know, confidentiality beyond the statutory and contractual provisions.
If I may just add that even Malaysian Arbitration Act has a default provision that all court proceedings relating to arbitration will not be held in open court unless the court otherwise determines. So probably we could also have such a provision in our Arbitration Act. So in order to satisfy the parties, look, this confidentiality is not restricted only till the stage of arbitration, but it will be preserved right throughout till the end, till the matter is finally settled. I think that will give a lot of confidence to the parties, especially in cases where sensitive information is involved and parties may be apprehensive if disclosed, it could harm their interests or it could be misused by somebody else.
Thank you, Dinesh ji and Dhirendra ji. Moving from confidentiality, it's important for us to move to the next topic, that is cybersecurity. The preliminary difference that I notice as a novice largely is that while confidentiality operates by parte, as Dhirendra ji said, cybersecurity operates in REM. So my first question is to Dhirendra ji, sir. Can you tell us why is cybersecurity so crucial in today's arbitration?
See, there are a number of reasons why it is important. First one I have already mentioned, and which I think is very important. The sensitive business information in a commercial dispute or between 2 commercial parties could be really important for one party. And if that information which may be necessarily used or to be used either to pursue a claim or to defend a claim, if it has to be used in the arbitration, that information has to be protected. And if it somehow leaks out, if there is a pilferage of that information, tremendous loss can be suffered by that party just because of having chosen the option of arbitration. That's one thing. Second thing is as we are gradually and consistently moving more towards the digital data, everything, these days arbitrations have huge documents which are involved. So everything is getting digitized and everything is being transmitted, online. The data is being stored in cloud services or at other places. The integrity of that data is also very important, so that no third party accesses that, has access to that information or anything relating to the arbitration proceedings. And in fact, it can also happen that wherever that, even during the course of transmission or during the course of the storage of the particular information, that information relating to the arbitration can get compromised. And if somebody has strong ill wills, they could even make the data completely inaccessible to the parties. So it could defeat the whole purpose of the arbitration. And in fact, that could, you can think of some extreme examples where the whole integrity of the arbitration process can be put to doubt, and any award passed pursuant to that such a scenario can be challenged easily. Look, everything was compromised in this arbitration, and ultimately, everybody using the arbitration will get a bad name. There's a huge reputational damage not only to the parties but to the whole system. So, as of now in India, I don't think we are taking it that seriously, but I'm thankful that this very, very important topic has been brought up for discussion, and I hope there are further discussions on this topic so that we start taking seriously these issues, and so that we just don't land up one fine day to realize that, oh, in that particular case this happened and everything got totally blacked out or something of that sort.
Can I just add?
Certainly.
So I think the solution is go back to hard copies and let's not file these soft copies on a lighter note. But I think it is not out of place. There have been two instances, two case laws that I've come across. One was a Chinese and Philippines dispute where there was, if I read, it's China-Philippines South China Sea dispute where Chinese state-affiliated hackers deployed malware software on the case website, infecting lawyers, and they stole confidential documents and arguments. That is one instance. The other one was a Turkey dispute. So it has already happened. So therefore, we have to be very careful on the measures that we need to adopt, and parties need to obviously rely upon more credible, I would say, softwares like maybe, I don't know whether Zoom is or not, but ICC of course has provides for it. So similar, something that we need to create for, as we are sitting, and I would request Justice Gupta that to think about it so that we have something in-house for IIAC where we keep confidential so that people rely and have trust in the system. So I think that would be my suggestion. Thanks.
Thank you, Dhirenji and Dineshji. Moving forward from cybersecurity, in some ways coming to documentary and evidence, how does data tampering take place in the modern world, and how in this post-truth world, I would say, in an AI-driven world, someone makes a difference in what is a correct document and what is not, and how does it impact arbitration?
I think it's more of a reputation for everyone, all stakeholders for arbitration, where fake documents are produced, fake case laws are produced, fake conversation in terms of emails are produced. So it has become very sensitive, and obviously you can't stop all that. If people have to do it, they do it. But you have to be careful. So procedurally, I would say that you have to be very careful when you are doing your admission denial of documents. When you are actually, you have to cross-check the document filed by the side, even if they are filed from some government website. So I think those are the precautions someone has to take to ensure that this data tampering, obviously you can't stop, but you can ensure, I've seen while doing admission denial, they just look at it whether this document is on your letterhead or not. So you have to go deeper into it. To my mind, it should take more time for you to ensure that you are dealing with that issue then and there, so that the credibility of the document has to be challenged at that stage itself. Yeah, thanks.
May I just add, Kanu?
Certainly.
So recently we came across some judgments which were AI-generated judgments which we saw in one of the submissions. So this is what I told my client. I said, listen, this is an adversarial system. I can catch on the legal authorities being wrong. I can't catch on the evidence being wrong. So, somewhere you step in and you tell me whether or not these letters were actually written by you, whether or not these reports actually exist, and we check on the legal part of it. So yeah, let's work together in the AI world.
Also, just to add just one more point, that there should be some consequences attached to it. Like if you're able to get away by doing it, then it's like, okay, kara bach gaye, koi baat nahi, it has no consequences. So I think you have to lead also by example in the sense some deterrence has to be there for doing it. And maybe it may sound harsh, but in the beginning when the practice starts happening, there has to be some strong steps being taken to prevent it. Otherwise, if we allow people to get away with it, it will be very difficult to regulate.
I think it has to go beyond good faith and fairness principles now.
We have to move away from the British gentlemanly principles. There has to be consequence.
But let me tell you one thing, a new issue which is coming up, and some people have started raising concern as to the misuse or pilferage of the information without the parties knowing about it, that this has happened. Okay, people have raised concerns that you are making use of emails without encrypting them and sending attachments which are not password protected. You never know who catches those emails in between and does what tampering to them. Even the iCloud service providers, they can pilfer the information that you store thinking that it is secure, but that the iCloud service provider could be using that information either for his business or there could be chance that information could pilfer out and reach to your competitor. So, this is a new thing which has come to light. So where do we stop and where do we draw the line?
That is exactly my next question is, suppose there is a cyber security breach, what remedies do I have? What remedies do I have as a lawyer and as a client? Abhisarji, can you tell us?
Okay, so I can tell you the combinations, permutations, combinations I could think of for that. So 42A, of course, if you can say that it has been by one of the parties, or it has been, the three things that we've been mentioning, three people, the three parties that are covered. So, but yeah, of course, it doesn't cover what if it is by some translator, if it is some, by, say, the provider of a platform or a Zoom provider or anybody of that sort. So see, if it is by one of the parties, then there are, and I've found at least 2 judgments on it where the court has done something about it. In one of them, the arbitrator was, it wasn't exactly a cybersecurity issue, it was a security issue, and that it was more of a confidentiality issue when the arbitrator was changed. Okay, so if it is by one of the parties, yeah, it's a breach of statutory obligation, go for damages. You can ask for injunctive relief. If it's a very, very severe case, you can go for a contempt. Okay, but let's face it, it's usually by third parties. It's not going to be by one of these parties. So 42A might not come really handy. In that case, if preemptive approach that I could think of is that going forward in your agreements, let's just have a clause about it. Let's have a clause about it as to who all should have an access, what happens if there is a misuse, there's a cybersecurity issue, and how we are going to deal with it. Let that be ingrained in your contract. I think that's one thing that I can think of. And then we obviously have the new annual DPDP Act, and how do we apply the DPDP Act? Now I can think of saying that, of course, somebody is a fiduciary. The penalties run really high, but again, how do you determine, is an arbitrator a fiduciary? Are you going to punish the arbitrator? Are you going to punish somebody who's a transcriber and who has the access? And DPDP says that you cannot retain data beyond a certain point of time, after which it is not required. But then again, who is holding it? Who are the people? And unless, we have some case laws or some notifications saying that we need, how to find a tandem between the 2 acts. I think if there's a cybersecurity attack, you pray.
Thank you for your comments. Moving from that, as far as I understand, one of the issues on this, arbitration is a private dispute resolution. It doesn't really have an inherent power of court. So suppose in a particular case there is a cybersecurity breach, is it possible for a party to move under Section 9? Because the Section 9 court would certainly have powers, and 9 would be available at any stage in an arbitration, and orders can be passed even against third parties. Is that something that you believe can be explored, and jurisprudence can be developed on that front?
I guess so. Because it's speculative, because it hasn't happened. So Article 17, even arbitral tribunal is also available. So why only Article 9? Maybe we can approach the same arbitral institution or arbitral tribunal to take some measures, to take cognizance of that and to proceed accordingly. So see, confidentiality has actually become much more important post-COVID, because once we have started, gone online, once we have entered in that third space, to function, confidentiality has suddenly become more important, because the leakage points have increased many folds. So earlier it was simple security, tala lagana. Now it's not simple, there are no more hard copies, so you don't have to put a physical lock. So now you have to put locks in the virtual space, which of course we are all struggling with the word over.
Certainly, I think we have come the full circle in this, in my short lifetime. As in the 90s, everyone used to say that, this record has been digitized, so now it is safe, nobody can touch it, nobody can tamper it. And within 2 decades, we are at a situation that we want to go back to those physical things to ensure that it is untamperable.
And this takes us to, in some ways, the elephant in the room, that is the DPDP Act and the DPDP rules, the recent 2025 rules. Nitiji, can you tell us what is the framework? Because it's a relatively recent enactment, and I'm not really aware of any case law on that aspect. Can you tell us how do these rules and this act culminate into functioning? What is the function of the board? How do the appeals go to the tribunal? And how does it possibly impact arbitration?
Now, as Abhisar said, it's like it's really a new infant on the block, not even a new kid, it's really a new infant on the block. So we all have to figure out like how it works. But talking about DPDP Act, as everyone knows, like you spoke about right to privacy and Puttaswamy. So one can, I think, safely say that DPDP Act kind of gives body and flesh and muscles to that right to privacy, because it now says that how privacy needs to, what is the meaning of privacy and who is accountable and who is responsible for protecting that. So it talks about data fiduciaries, it talks about data principle, it also talks about significant data fiduciaries. Now, it is not saying too much about arbitration there. It's difficult, it has to still decipher its relationship with arbitration. The arbitral tribunal now would be expected to be, or arbitral institutions would be probably expected to be data fiduciaries. And they would have a larger responsibility and obligation to protect the data. And with this DPDP Act and rules, we're also supposed to have a board which will now hear the complaints, breaches, so maybe we'll have, at least we have a forum, we have an avenue where the issue relating to breaches can be taken. But then the issue will arise would be that what would be this data protection board's relationship with arbitral institutions? Will it, if there's any breach, is it the only body to hear the breaches scenarios? As you raised the previous question, can we invoke court under 9 or arbitral tribunal 17? So like, because it will be now multiple forums, so is data protection board will be the only forum for listening every kind of data breaches, or it will be a supplementary forum, additional forum. So we will have to like look into that.
I believe that's an interesting perspective. As far as I remember, there's a bar for civil courts. So yes, we'll have to see which way the jurisprudence goes on that. Dineshji, as a practitioner, can you tell us in terms of the DPDP rules 2025, how can arbitral practice really leverage those rules in order to take care of the concerns that you just shared with regard to cybersecurity and confidentiality in general?
So as Nidhi mentioned, I don't think there is anything specific covered for arbitrations. And I would say we are still struggling and trying to have clear position on Arbitration Act. I don't want another DPDP Act to be interpreted and to complicate my life. So I don't think there is much in DPDP Act, because in fact it carves out an exception for judicial proceedings. We are neither data fiduciary, nor are we processing, nor are we principal, because it's more on personal data that the DPDP Act talks about. So I'm not sure whether it does, and I'm assuming it should not, because our Arbitration Act is good enough. Whatever protections that we need, whatever enhancements that we need, I think should be covered in the Arbitration Act itself, because it's more like a dispute between two parties, and parties should be free to implement. But of course, a framework is required, which Arbitration Act has provided, but we need to just strengthen it, and institutions like IIAC or MCIA, I think those are robust enough to take care of other incidental issues that we are still struggling with. And since the time is changing, we need to modify and keep ourselves completely sort of inclusive, make it more inclusive, so that whatever concerns have been identified today should be captured. Like, you know, the tribunal interpreted in my case parties to include their counsels also. But now we, of course, deal with various experts and consultants who are part of this arbitration should also be covered. So I don't think DPDP Act covers or should be covering it. It is more Arbitration Act, and institutions should be taken care of. Thank you.
Just to add, I agree with what Dinesh has said. Even I have my doubts whether this DPDP Act would be applicable to the arbitration proceedings. And I can only hope and pray that it does not. I mean, no, in future, nobody holds that it is applicable, because it can, if it's so held, then it will be very problematic for everybody who are concerned with arbitration. It has a lot of ramifications.
We appreciate that, sir.
Coming to you, Abhisar, do you believe that this framework, if truncated in a specific manner or maybe applied with a separate set of rules to arbitral proceedings, can be helpful? Because it does create a right with regard to data protection.
You're saying about DPTP?
Yes.
Yeah. See, as things stand at present, no. I think we need a lot of judicial interpretation to be able to move or a notification to plug it in. Because there are a lot of questions that need to be answered. You know, is tribunal secretary a processor, or arbitrator a fiduciary, lawyer a party? You know, there are too many questions to be answered. And it's a pity because this has come, see, when 42A came into existence, that's when cloud was a cloud, right? Nobody expected cloud to mean so much more. So, but when DPTP came into effect, arbitrations actually existed. And yeah, if I speak from a very personal and selfish point of view, I'd agree with the right side of you that, yeah, I agree, we don't want any more complications. We've had enough. There's just so much to keep up with in arbitration anyway. But yes, probably if there is something, if you know, we're not seeing any changes to 42A as it exists at this point of time, then probably if DPDP has, you know, not wait for judicial interpretation or be tried in courts and just comes up with something which really covers arbitration, I think we'd be through. Because, you know, there are these questions that now we look at, that, you know, how do we use, see, because in any arbitration, in any international commercial arbitration, you're looking at parties sitting in 2 different jurisdictions and arbitrator sitting in a 3rd jurisdiction, transcriber sitting in some other jurisdiction. So this is an international use which DPDP is talking about. So if we have some kind of rules which kind of make a bridge between arbitration and DPDP, then in an ideal world, yes, I think we can be able to solve this issue in terms of arbitrations.
Also, just to add, and not from any selfish perspective, even from a very academic perspective also, I think DPDP Act kind of protects right to privacy for those for whom it didn't exist, or this existed, but arbitration, as I said, arbitration confidentiality has been an integral part of arbitration. So privacy and confidentiality have always existed with arbitration. And this is not a new right which has been declared or created. So it can't be called a right under Article 21, which is created for the parties. So arbitration, in fact, institutions or whatever is the mechanism, has to have a mechanism for protecting privacy, which cannot, I think, overlap with DPDP. According to me, DPDP Act and the rules have a different scope of application. Their scope of application is not protecting data in dispute resolution. And I would say it will be sooner that we clarify this, better it will be in the interest of India as a seat of arbitration also, because we have now a new block with new, like as we say, new kid in the block creating confusion. Now there is one more relationship to be sorted.
Academically approved.
I'm happy to note that there is consensus in the panel on this issue.
But may I give a suggestion to Nidhi? Because I was also going through this act. So kindly later on offline you could consider the interplay between section 17, which says that these provisions will not be applicable except sections 8, 1 and 5. So it creates a lot of doubt as to why sections 8, 1 and 5, which create obligations upon the data fiduciary to ABCD things, and then the schedule also levies a penalty if there is a breach of section 8.5. So what is the interplay between section 17 and, see, section 17 on the one hand says that it is not applicable, these provisions are not applicable to legal proceedings or arbitral proceedings, but then it leaves a window open except section 8, 1 and 5.
Yeah.
So probably as an academician, before anything, before you see the judgment, probably you could come out with some paper which could assist us.
I have a rather practical question to actually all the panelists. Suppose it is an ad hoc arbitration and pleadings were being exchanged on, say, one of the major websites or portals or email services, say a Gmail, and a lawyer is representing a publicly traded company. The leak takes place with regard to certain extremely confidential data with regard to that company, which severely impacts its stock price. Now, the leak has taken place not at the end of the arbitrator, it has not taken place at the end of any of the parties or the stenographer or anyone. It has taken place at the end of this data fiduciary, if I can say. What is the remedy that a person has in that situation?
Sorry, who's the data fiduciary here?
The email service provider.
No.
There is no obligation on them to keep it confidential.
Exactly.
So they will not be.
But the parties would still suffer consequences.
Could have a tortious, maybe a tortious action would lie, because otherwise at the moment I don't think there is any law governing this situation that you have just mentioned. I may be wrong, but please, there could be a tortious action which could lie, but not within any framework of any statute. That's what my thinking is.
It will be something like intermediaries liability, which has to be limited. So email service provider, can it be considered fiduciary? I think that's one of the most important issues. Who is fiduciary? Because DPDP Act is talking about data as fiduciary and significant data fiduciary. But there is not much clarity as to who can be considered.
And you'll have to also consider whether Gmail actually says that they will always keep it intact, like WhatsApp claims that all encrypted, and therefore then you can still, because there's a representation, you can go after them. But I'm not sure what Gmail terms and conditions would be.
I'm sure I have never read the terms of agreement of Gmail or any of these service providers, but I'm 100% sure that in that form which we blindly say I agree and we click on that, there must be a disclaimer clause saying that we don't hold any responsibility because of if any mishap happens by the use of our services.
I believe that's a separate debate altogether with regard to click-wrap contracts, which are standard format and which nobody has ever read. I think with this, it's a good primer for us we'll come to the questions, sir. Just there's a couple of questions left. We'll come to the questions from the audience. The next topic that we are going to discuss is privacy in arbitration, and my first question is again going to be Dhirendraji. Sir, how do you differentiate between these seemingly overlapping concepts of confidentiality and privacy? And how can they be distinguished and then utilized in order to ensure that the arbitral process is carried out in a safe manner?
See, without getting too legal about the difference between privacy and confidentiality, I think if I may try to put it on my own words, privacy is about a right and confidentiality is about an obligation, right? For example, let's take this hall. If we declare that this is a private gathering, so no third person has a right to enter and to know about what is happening in this room or in this hall. But if we say that, look, whatever we discuss today in this hall will be confidential and none of the participants here will disclose to the outside world, then what we are doing is we are importing an obligation. Now, I'm trying to be very simplistic about it. So confidentiality is about obligation, right? And even several of the institutional rules recognize this distinction, but treat them almost as the same level. For example, all the proceedings are considered to be private in terms of the rule, and anything which is any document or any discussion in relation to the arbitration proceedings is considered to be confidential, not to be disclosed. So I hope I have clarified on that account.
Certainly, sir.
I think I think these are two sides of a coin, and like lawyers have complicated seat, venue, and place, we are very well capable of complicating privacy and confidentiality. But I think there is a recent Supreme Court judgment where it has said privacy and confidentiality go hand in hand in arbitrations. Yes, there is a difference in some countries. In my view, Australia says that arbitration provides privacy, that no third person can come and hear you, but maybe it does not provide you protection for confidentiality. They leave it to the parties to provide for confidentiality between them, as Abhizar mentioned, that few countries do not provide for it. So I think that's the way it is, but I don't think in India it is being differentiated between privacy and confidentiality.
Let me just add, like for example, you talked about the Australian. In ICC rules protects privacy. It expressly says that no third person will be admitted to the hearings. But it doesn't say anything about confidentiality. Right? It has left it open. But take for example IIAC rules. It does mention expressly that the hearings will be all private, no third person will be allowed. And there is also a provision separately that what is confidentiality and how it will be protected.
That's very interesting observations on, since you talked about seat and venue. Recently read a judgment by the chief guest for today's function. And there's a line in the judgment that the over-intellectualization of arbitration issues is the bane of Indian arbitration. I believe it's an extremely appropriate line. Nidhi, can you tell us to what extent parties and stakeholders to the arbitration process can self-regulate in order to minimize the privacy risks?
Well, as I said in the beginning, regulating privacy and confidentiality is like regulating ethics by law. So the starting point has to be self-regulation. And actually whether there will be confidentiality or not will depend on whether parties are self-regulating. But then breach of confidentiality can also be a strategy. Breach of privacy can also be a strategy. So I would say its starting point has to be self-regulation. And then any kind of a breach, whether it is accidental or whether it is intentional, that has to be then looked into and treated separately. Because there can also be a lot of accidental leakages, and then for which probably no one can be held responsible. Because when dealing in cyberspace, but the possibility of leakages at times also is there, that it is accidental. And then could be as probably a tortious liability, or whether that exists at all or not. So that will come in. But to answer your question very precisely, the starting point is self-regulation.
Thank you, Nidhi. And my last question is actually to all panelists, and all of you can contribute on this. Is with your experience as a practitioner and a practitioner across jurisdictions, what risks have you located in your practice, and how do you believe that different institutional arbitration centers across the world deal with those risks? Dineshji and Abhisarji, if you can specifically deal with that question. Privacy.
I've not come across, but let me share an example of what happened. So it was a dispute there were two disputes, employer, contractor and subcontractor. So sometimes contractors take slightly different position in their dispute with employer, slightly different position when they are disputing with the subcontractor. So there was a counsel A who was representing employer. When the dispute between contractor and subcontractor started, subcontractor engaged counsel A in the other arbitration also, obviously with the intent. And when the second arbitration between contractor and subcontractor started, there were a couple of documents produced from the first arbitration. Now, we said, look, it's confidential and that document cannot be produced. But the answer was that, look, no, we got the document from somewhere, but the subcontractor was not able to justify how he got the document. You get it through an email or you get some receipt. He was not able to. So the tribunal could see through that the same counsel, common counsel, has obviously provided this. So it is tribunal who pulled up the counsel, and in fact, they were noting in the award that it is obviously has to be conducted in a good conscious manner, and this document seems to be obviously breach of confidentiality of the first arbitration and has been produced. So it is, I think, more case-to-case basis and more depends upon the tribunal how it deals with it. I mean, ICC or Arbitration Act will only provide you a framework, but actual instances have to be dealt with. As I said, parties have to be careful when they are doing admission denial, when they are questioning these documents. Sometimes parties just copy the emails and paste it. But you have to see whether the email is actually the same email which was sent So I think those are the steps taken by the councils, and the tribunal then deals with these peculiar issues. Thanks.
Visaji, last words.
So I've seen it at least in 2 international institutions lately, and this is after post-COVID. Before every arbitration, before every virtual hearing, they would ask us who are the people who are going to be participating. They needed all the details on these people. How are they connected to this arbitration? Have they been on any of the hearings? Have they been in any of the communications, etc., etc.? And then they would insist that everybody turn on your camera. Please show us the room that you're sitting at. And these were simple hearings. These were procedural hearings, every hearing, and we were going through it. And at that point of time, I wasn't really happy with it because it was just too tedious. We had you're getting 5 minutes to present your case, and then you're just taking like 10 minutes to do all this. And I used to find it a little cumbersome. But looking back at it, I kind of understand that why they were going through it. And these 2 tribunals, then one was an ICC, one was a CIAC, and they followed it throughout their virtual proceedings. And even till the end, they used to ask us if there was a new email address that was added. They would always ask that, who is this person? Why has this person been added? And you had to give an explanation before every hearing. So yes, it was a little cumbersome, but I think that those kind of, with the way that we function, there are emails, CC'd, BCC'd to oblivion. You don't know who is accessing from where. You are sitting in an institution, your transcriber is sitting in a cafe in Bali. So you really need to have that kind of information to be able to secure, for cyber security reasons, and I do get it. So I think those are the kind of, we'd have to take those measures. Yeah.
Thank you. I specifically thank the speakers. I think with this we have come to an end of today's discussion. If there are any questions, I believe we have about 2 minutes or 3 minutes to take a couple of questions, that's all.
I'll just read 3-4 lines from a recent judgment of the Supreme Court. You may have come across it, but then still I think they are the relevant lines. Supreme Court says, at this stage, it is necessary to refer to the provisions of Section 42A of the Act. The arbitrator, the arbitral institution, and the parties to the arbitration agreement have to maintain confidentiality of all arbitral proceedings. The legislative intent behind maintaining confidentiality of information is quite clear. Permitting a stranger to the arbitration proceedings to remain present. Now this, according to me, this would include even in electronic format or whatever, or personally physically present. Permitting a stranger to the arbitration proceedings to remain present and observe the said proceedings would result in breach of the provisions of Section 42A of the Act. Even on this count, the impugned order cannot be sustained. In this matter, somebody wanted to intervene, he was not allowed to intervene, then he said, let me remain present in the arbitration. That was allowed, so that has been set aside. So this judgment is of Justice Narasimha and Justice Chandurkar in the matter of Kamal Gupta versus LR Builders Private Limited. Just sharing information.
I have one clarifications. Sir, the learned arbitrators, we believe that they are passing an award based on documentary evidence, contract provisions, and public policy taking into account of the natural justice. Then what is the necessity to have confidentiality in arbitration? If so, it has to be maintained. What is the direct disadvantage to the parties if confidentiality is not maintained?
So,
Sir, we heard you. Let one of the speakers answer.
So there are 2 ways to resolve, whether you go to court or to arbitrators. Some parties don't want the matters to be heard in open courts, and therefore they go for arbitration. And therefore, it's inherent in arbitration that they are to be kept confidential. Now I understand your point that not all matters are required to be kept confidential, but because it's the inherent advantage of arbitration, parties don't want their names to be thrown out or their documents to be made public or their information to be made public. So for that purpose, they want to keep it confidential.
What is the disadvantage in case it is not maintained?
It may not all the matters may have disadvantage, but some will obviously have a disadvantage where their public data will be disclosed. Maybe they are public listed companies, maybe they are companies into defense. They don't want their data to be out. Could be multiple reasons.
One last question, please. We are really running out of time.
Thank you so much for such an enriching panel. I loved every bit of it, how we talked about different jurisdiction. And one of the comment was also that ICC has their different clout. So IIAC should also think about all these things. While I understand that having a privacy compliance give the efficiency to the whole arbitration as the procedure, but what do we do about the cost? Because having a separate cloud, having the separate channels of storing information would also incur cost. And one of the pillar of arbitration is also to make it cost efficient. So how do we strike a balance?
I don't think cost efficiency anymore is applicable or is an argument that you can make. But yeah, if you want all that infrastructure, you need to maintain confidentiality. Obviously, there's a price to it, whether you take it as SIAC or ICC or any of these institutions. But yeah, I understand your concern, and I think that's where institutions like DIAC, IACC fulfill this mandate that you're thinking of or the wish that you have. I think that is why I requested that we need to consider that infrastructure in India, because we are giving work to the entire world. Singapore has more than 50% arbitration where Indian parties are involved. So if we build up that infrastructure here at an economical cost, why not? The cost which you pay to DIAC or IAC is, I would say, 1/3 of what you pay to ICC. Less than that. So if you have the infrastructure, why not? Why do we look at ICC only? So
I just want to tell here that in IIAC we do have our separate cloud. So we have kept our separate storage, and where all the data of the arbitration is being stored at our separate server. It is not on this.
That's where your answer is.
We have.
Just to add to that, just to give a little perspective, considering this technology, the pattern that we've seen is that technology gets cheaper the more it gets widely adopted. So that is also one thing that I'm waiting for, that it might just get cheaper to have all these new techs.
The gentleman also said on contract, the best part of it is that the electronic part, what we are talking about is the physical contract. If we talk about the electronic and digital contract, that is nothing but blockchain. Blockchain has been given a bad name by certain people in Bitcoin and others, but it doesn't absorb that much of energy even if it is a contract, and that is very confidential. There are two types of blockchain. One is private, has a private key, another is a public key. So public key can be, the documents and everything can be in the public domain, but in the private key, everything is confidential. A to Z is confidential. We don't need any cloud. We don't need anything. So even the case which you were talking about, the email was hacked. I have dealt that is a Canadian case. I have dealt with that, and the share prices went down, and the compensation was granted for the fall in the share market prices. That is what I wanted to tell you that time.
Thank everyone.
In international arbitrations, all GDPR is compliant. It has to be GDPR compliant, and that is similar to the case of DPDP Act. So how we can isolate from that DPDP Act? It is definitely not. I mean, I'm in my opinion, it cannot be basically said. Moreover, there is an IT Act. There are specific provisions under IT Act, that is 66E, that talks about the privacy compliances and confidentiality. That also cannot be breached because there is a punitive danger. There is a 3-year punishment to that one, and under DPDP Act, there is a penalty up to 250 crores, and that includes all sensitive data, all an fiduciary, data fiduciary in terms of all those things. Because he maintains all those data which are parties in giving. So in that sense, he is a data fiduciary. And the role of all other linkages, that is the Gmail, the all service provider, etc., or all those things which are providing all assistance, they are clubbed into all those.
Appreciate that. We appreciate
so those
that.
cannot be, you can't exclude those, you can't immune those.
So please, please consider one thing. In a claim of 10 lakh rupees, suppose if the arbitrator, as you say, is a data fiduciary, if he commits a breach, you don't mind exposing that arbitrator to a penalty of 250 crore rupees. Just think about it.
That is agreeable. But the law is always there. You can't just immune yourself just because.
I believe the debate can go on, but we have come to an end of the session. I thank the audience for listening to us patiently.
Hello. Thank you to our moderator and esteemed panelists for a thoughtful and engaging discussion. Your insights significantly contribute to the ongoing dialogue on technology, privacy, and modern arbitration. With this insightful discussion drawing to a close, we may now proceed to felicitate our speakers. May I request Mr. Vinay Kumar Sanduja, Registrar IIAC, to felicitate Mr. Dhirendra Negi. On behalf of everyone, I welcome our honorable chief guest, Mr. Justice P.S. Narasimha ji. Thank you, sir. I request Mr. Vinay Kumar Sanduja, sir, Registrar IIAC, to felicitate Mr. Dhirendra Negi, sir. May I request Mr. Karan Kanwal, Deputy Registrar IIAC, to felicitate Mr. Dinesh Pardasni ji. May I request Mr. Ashish Padam, Counsel IIAC, to felicitate Dr. Nidhi Gupta. May I request Ms. Niharika to facilitate Ms. Abhisar Bairagi ji. Now, may I request Ms. Kanika Jain, Private Secretary to Chairperson, IAC, felicitate Mr. Kanu Agarwal. We extend our appreciation to each of you for your valuable contribution, and we want you to be there for one photograph, please. Thank you, everyone. We now turn to a significant moment of institutional collaboration, signing of a Memorandum of Understanding between the India International Arbitration Center and Paryay ADR Society of Law Center 1, Faculty of Law, University of Delhi, reflecting a shared commitment to support academic engagement and nurture emerging talent in the field of dispute resolution. Before proceeding with the signing of MOU, may I invite Advocate Komal Bharti and Advocate Suganya to briefly share the vision and mission of Paryay.
We are truly honored to speak today at the MOU exchange between India International Arbitration Center and Paryay, the ADR Society of Law Center 1, University of Delhi. The journey began with a small group of students, curious, enthusiastic, and united by their interest in ADR. And the idea found direction and strength, fueled by the unwavering support of the IIAC, significantly shaping our journey, offering remarkable exposure and support throughout. I still remember, despite a short notice, when we invited Honorable Justice Hemant Gupta sir, he graciously accepted the invite to inaugurate our society, arrived with the entire IIAC team, listened to us with patience and encouraged us generously. It was during his inaugural address that Justice Hemant Gupta endorsed the idea of building a stronger relationship between IIAC and Paryay. His commitment was clear. He wanted to create meaningful opportunities for young law students in the field of ADR. And today, as this MOU finally comes to life, we are extremely grateful for he trusted our capabilities and supported us throughout.
The students of our ADR Society over the past academic year have had the privilege of participating in stellar events organized under the aegis of IIAC, including the colloquium, the Oxford-style debate, the conferences, to name a few. These platforms gave us an opportunity to witness distinguished legal luminaries pave the way for a dynamic institutional arbitration ecosystem in India. At this moment of celebration, we would like to thank everyone whose dedication and efforts have contributed to the formalization of this MOU. In particular, we extend our heartfelt gratitude to Mr. Naveen Kumar Singh, CEO IIAC, for his willingness to engage with the student community, Mr. Vinay Kumar Sanduja, Registrar IIAC, and Mr. Karan Kanwal, Deputy Registrar IIAC, for their constant support, and Mr. Ashish Padam, Counsel, whose guidance was instrumental in bringing this MOU to fruition.
We are equally grateful to our University Dean, Faculty of Law, Professor in Charge, Law Center 1, and to our Society's Faculty Convener, Professor Dr. Sunanda Bharti, and Faculty Co-Convener, Professors Apeksha Kumari, Alok Sharma, Siddharth Mishra, Kavita, and Sukanya Singha, for their insights, encouragement, and goodwill, which made the signing of this MOU a reality. The MOU would not have been possible without the tireless effort, passion, and belief of our student body, the foundation on which this association stands.
As we formalize this collaboration, we do so with a shared belief that young minds, guided by strong institutions, can shape a more harmonious and equitable future. Thank you all for being part of this memorable occasion. We look forward to a long, impactful, and enriching academic collaboration ahead. Thank you.
Thank you. Thank you, Komal and Suganya. Now I invite Mr. Naveen Kumar Singh, CEO, IIAC, and Professor Dr. Sunanda Bharti, Faculty Convener, Paryai, on the stage for kindly proceeding with the signing and exchange of MOU. It will just take another 2 minutes. My apologies. A warm round of applause, please. We thank both of you for formalizing this partnership. Thank you. Carrying this spirit of collaboration forward, we now proceed to another significant moment, the launch of IIAC Magazine. May I invite Honorable Mr. Justice P.S. Narasimha, Judge, Supreme Court of India, and Honorable Mr. Justice Hemant Gupta, Chairperson IIAC, to please be on the stage. And with also today there is Anand sir, Anand Vijaypalli sir, member IAC with us. I request Honorable Chairperson sir to welcome and felicitate our chief guest, Honorable Mr. Justice P.S. Narasimha. I request Honorable Chairperson Sir to welcome and felicitate our Chief Guest, Honorable Justice P.S. Narasimha. Now, may I request Mr. Naveen Kumar Singh, CEO IAC, to felicitate Honorable Member Vijay Palli sir. Thank you, sir. Before inviting our chairperson, sir, to share his thoughts, may I have a privilege of introducing him briefly? Honorable Mr. Justice Hemant Gupta belongs to a family of well-known civil law practitioners at Chandigarh. As an advocate, he dealt extensively with civil, revenue, labor, arbitrations, commercial and constitutional issues. He was appointed as an additional advocate general for the government of Punjab in the year 1997 and served as such till the year 1999. He was elevated to the bench of the Punjab and Haryana High Court in the year 2002 and served at that court up to the year 2016. During his tenure at Punjab and Haryana High Court, he delivered several judgments on issue of civil law, revenue law, tax matters, commercial disputes and arbitration matters. In February 2016, he was transferred to the Patna High Court, Bihar, and also remained acting Chief Justice there up to March 2017, before his appointment as Chief Justice of Madhya Pradesh High Court. He was appointed as the Chief Justice of Madhya Pradesh High Court in March 2017. He was elevated to the Supreme Court of India in November 2018 and served until his superannuation on October 16, 2022. In the course of tenure as a judge of the High Court as a judge of a Supreme Court, he has delivered several path-breaking landmark judgments, including on civil and contract matters. Currently, he is serving as a chairperson of the India International Arbitration Center. Now, I invite Sir to share his thoughts.
Good evening, respected and dear friend Justice Narasimha, and also my friend, old friend from my Chandigarh days, Anant Vijaypalli. We are meeting in a very momentous event when we are publishing our first annual magazine. In a way, this magazine sums up our journey of 3 years, because it was 2022, December 22, we took over, and in 3 years, whatever we have done, we have tried to crystallize in these about 100 pages or so. I must say that Justice Narasimha, as a Additional Solicitor General, was member of the Shri Krishna Committee, which recommended the amendment in the Arbitration and Conciliation Act, and also establishment of India International Arbitration Center Act, and also the Arbitration Council of India. So he is actually the founding member of the India International Arbitration Center, and we are the privileged beneficiary of his vision at that point of time. The magazine is, as I said, that is a compilation of our history of 3 years. But we are also lucky to have articles from different dignitaries, the known arbitrators. Some of them I will like to name. One is Mr. V.K. Raja, who is a famous arbitrator based in Singapore. He is basically Singapore, Sri Lankan native. He was Attorney General for Singapore and also Judge of the Supreme Court of Singapore. He is real friend of India who like to promote India as on the world scene. He has contributed an article. We have also an article again from Justice L. Nageshwar Rao. Now we were sharing bench. Now he is a known arbitrator in domestic and international arena. We have also an article from Mr. Professor Sundara Raju, who is again a famous arbitrator based out of Malaysia. In fact, we had one international arbitration between India and US company, and both of them said that we want an independent national. So Professor Sundara Raju was chosen an arbitrator, and he has probably given his award also. Similarly, we have an article from Sharina Petit. She is based out of London, basically belongs to Bombay. And also a young advocate based out of London, Vishnu. He has also written on cross-border arbitration. So we have a variety of articles from different distinguished persons, and we will have the opportunity to get it inaugurated from the hands of Justice Narasimha. I will not take much time. I will only say thank you all of you for gracing this occasion on this momentous occasion. Thank you very much.
Thank you, sir, for your kind words. We now proceed to a key moment in this afternoon's program, the official launch of IIAC Magazine. Now I request Honorable Mr. Justice P.S. Narasimha and Chairperson sir and Honorable Member sir to please kindly release the magazine. Thank you, sir. Before inviting our chief guest, Honorable Mr. Justice P.S. Narasimha, to address the audience, may I have a privilege of introducing sir. Sir belongs to Hyderabad. He graduated with triple majors in economics, political science and public administration from Nizam College, Hyderabad, and pursued law at Campus Law Center, Delhi University in 1988. He enrolled as an advocate in the same year and practiced before the High Court, Civil Courts and Tribunals in Hyderabad and shifted practice to Supreme Court. He appeared in a large number of cases, included many constitution benches before the Supreme Court. During this time, he was also appointed as the Commission Counsel for the Justice Chinnappa Reddy Commission. He was a member of a Supreme Court Legal Aid Committee. He was designated as a senior advocate by the full Court of Supreme Court of India in the year 2008. As a senior advocate, he appeared in many public law cases involving constitutional, administrative and environmental issues. He is specialized in laws relating to telecom, competition, electricity, and other regulatory jurisdiction. He was the amicus curiae for the Forest Bench and other cases concerning judicial appointments, fast-track courts, and tribal laws. He was appointed as the Additional Solicitor General of India in 2014. During that time, he assisted the court as a law officer in several landmark cases, including the NJC case before the Constitution Bench. He was part of the Indian Supreme Court delegation to the Canadian Supreme Court, where he presented a paper on extradition and environment. He had the rare opportunity of leading the Indian team and represented India before the International Tribunal for the Law of the Sea in Hamburg, Germany. He also represented India before the Permanent Court of Arbitration, Hague, in investment treaty arbitration. He was part of the governing body of National Legal Service Authority of India and closely associated with the Mediation and Conciliation Project Committee of the Supreme Court of India. As a law officer, he was instrumental in constituting and being part of high-powered committee suggesting sweeping changes to the Arbitration Act and proposing a mechanism for institutional arbitration. He is closely associated with the making of the law on mediation. He was the member of committees relating to the restructuring of all appellate tribunal and reviewing the legal regime concerning corporate social responsibility. He has also been a member of the Investor Education and Protection Fund Authority. Additionally, the Supreme Court appointed him as a mediator in the BCCI case. He successfully facilitated negotiations between the members and the board regarding the organization of elections and the constitution of elected body. He had been on the executive council of many national law universities and other educational institutions. He was elevated as the judge of the Supreme Court of India directly from bar on 31st August 2021. Now I invite our chief guest, Honorable Mr. Justice P.S. Narasimha, to address the gathering.
Thank you. That was a very long introduction. Good evening, everybody. Justice Hemant Gupta, Mr. Palli, my former colleague, Justice Chima, Justice Anjana Mishra, the dignitaries who have come here. I must thank Justice Hemant Gupta for giving me this opportunity of seeing this IIAC, about which I had heard and about which we were discussing for a long time, but I had never visited this place at all. It's right, it's true that I have some kind of a connection to this institution. Very importantly, this is an institution which is recognized by the statute as an institutional arbitration. But it will remain in our arbitration history for yet another reason, which is that nothing else demonstrates the transition that has taken place about arbitration more than this institution. In recent times, individual contribution transiting into institutional contribution is very much to be seen in the landscape of arbitration. At a time when civil litigation was on, hardly anybody knew much about arbitration. We had sprinkling of counsels who were specializing in arbitration. And slowly we started hearing about arbitration. It had become generally acceptable in the sense that many of the individuals, some of our lawyers, colleagues were dealing with arbitration regularly. Then there was this issue as to whether it is only individual contribution and full stop, or is there anything further. That transition has taken place, and the success of it would definitely depend upon multiple factors. First and foremostly, whether there is an institutional conviction about arbitration or not? How much do we believe that arbitration as a remedy for resolution of disputes is viable or not? I can't say that it is 100%, but then conviction about arbitration is inching towards a belief that definitely arbitration can resolve disputes and that one can resort to arbitration for resolution of disputes. That conviction, if it lodges securely in the hearts of advocates and litigants, then perhaps we can say that there is an institutional conviction. We will still have to wait and see. But then the success will depend on yet another factors, that is institutional resource. How much human resource is fully equipped for making arbitration as an institution? Would depend upon the capability, the equipment, and the preparedness of quote-unquote arbitrators. I'm underlining this for the reason that it is not to be confined to lawyers or retired judges. What is the institutional human resource so far as arbitrator and arbitral stakeholders are concerned? The third important aspect when we are talking about institutional arbitration is what it lacked earlier, but it is fully now equipped with the authority or a recognition. Decisions of an arbitrator are well recognized under the statute, they could be enforced, and they can be implemented without any difficulty. One problem which we had about institutionalization of arbitration is about its infrastructure. I think with the amendment that has taken place to the Arbitration Act, arbitration institutions are slowly cropping up. We have institutional arbitrations in the sector where lawyers are coming together and formulating firms, and we have definitely quite a few number of institutions which are catering to institutional arbitrations. And this is a unique instance where IIAC is actually a institutional arbitration created by the statute itself. There is no parallel to it, and I wish it all success. And it is very, very important for all of us to ensure that IIAC works vibrantly and it becomes very, very acceptable amongst everyone. Yet another very important facet is institutional integrity. When we talk about integrity, we were referring to earlier about integrity of those who were arbitrators, and my view was it should extend to even lawyers also who were appearing. Integrity is an integral part of not only of the arbitrators but also to the lawyers who are assisting in completion of the arbitration. Without the total and complete integrity of both the arbitrators as well as the lawyers, the institutional integrity is nowhere near. Institutional integrity is not merely that, but there is something more, which is about how much are these institutions engaging with the subject matter of arbitration. How much are these institutions taking up and discussing the problems that are affecting arbitration? Reviewing the existence of present arbitration infrastructure, about its working. This review from time to time is going to be very, very important, and a reflection of that review will definitely be in the magazine that is brought out today. What this magazine does Like somebody said, a good newspaper is a nation talking to itself. A good magazine about arbitration, for that matter, will be about the arbitrators or the institution of arbitration or stakeholders of arbitration talking to themselves. It reflects and it comments and it criticizes and it appreciates the domain and segment of arbitration, on the basis of which I think everybody will be quite a bit benefited. This endeavor of taking out a magazine in which, as Justice Gupta has just now informed you, renowned persons have written on it, commented on subjects, and it updates our knowledge, it reviews the existing systems, and it also tells us what are the deficiencies and how we need to improve. My suggestion would be that if not monthly, at least once in 4 months, to start with, the magazine should be of a regular feature. You should endeavor to ensure that there are different sections in the magazine which talk about the way the institution is working, the way the world is progressing so far as arbitration is concerned, what new experiments are possible, how arbitration and mediation can go together. Also, you can talk about how arbitration should not be confined only to commercial arbitrations. In fact, I always believed that arbitration is something which is compellingly necessary for matters which are pending before civil courts for years together. But we don't talk about it at all. Therefore, a question arises, has arbitration been hijacked for commercial purposes? We can ask that question, we can challenge ourselves. If arbitration is a process by which dispute resolutions can be resolved with simplicity and expedition, I think issues like partition between brothers and fight between two neighbors can easily and quickly be resolved through arbitration. That process must be taken to the grassroots level at litigation and made an integral part. Court-annexed arbitration centers become important. It is not only through the government, but it is in the same manner that through Advocates Act, large number of lawyers are now in the private domain and contribute substantially to the nation building. In the same manner, arbitration should become an integral part of small and simple disputes which arise and plague our system. Finally, I would say that what I just spoke to you about is the institutional vulnerabilities. That is where we have that deficiency, how we need to improve ourselves is yet another aspect that institutional arbitration like IIAC will reflect upon. So over a period, I think there is actually a convergence of individual endeavor and institutional endeavor, and excellent, competent and capable individuals become part of the institution and they disappear. When I say they disappear, it means that there are no personal interests. What would prevail is only the interest of the institution. If we work like that, I think institutional arbitrations will be absolutely successful and will be of great benefit to the country and to the people of this country. I thank Justice Gupta for giving me this opportunity, and I wish you all the very best. Thank you.
Thank you, sir, for your insightful and gracious address. Now I invite Mr. Naveen Kumar Singh, CEO IIAC, to deliver the vote of thanks.
Good evening to each one of you. It is my pleasure to stand before you on behalf of India International Arbitration Center to deliver the vote of thanks and convey our immense gratitude and deep appreciation for on this special occasion. First and foremost, I extend my heartfelt thanks to our esteemed chief guest, Honorable Mr. Justice P.S. Narasimha, Judge Supreme Court of India, for graciously taking time out of his demanding schedule, and that too on working day, to launch the inaugural edition of IIAC magazine, The Equilibrium. Your Lordship, insightful reflections to the promotion of institutional arbitration in India, and more particularly the pivotal role that which IIAC play in the overall development of institutional arbitration and making India as a hub of international arbitration, have left an indelible impression on all of us. We are truly honored by your presence and inspired by your words, sir. I would also like to express my sincere gratitude to our chairperson, Honorable Justice Hemant Gupta, former judge of Supreme Court of India, for his leadership, invaluable guidance and support for the magazine's conceptualization to its successful launch. A big thank you to all the panelists for their astute deliberation and panel discussion on a very relevant topic. I am sure that all the participants must have benefited and enriched by their thought-provoking discussions. I also thank Pariah ADR Society for signing the MOU with us today. Our association will play a significant role in making IIAC a flagship institution for conducting domestic and international arbitration, and to make India a preferred seat or destination of international arbitration. A special note of thanks goes to Mr. Karan Kanwal, our Deputy Registrar, for his tireless efforts in bringing this magazine to life. Thank you, Karan. I also wish to acknowledge Ms. Nehal and Ms. Pranali, students of Law Center 1, Faculty of Law, University of Delhi, whose creativity and dedication greatly enriched the design of the magazine. Thank you, Nehal and Pranali. My appreciation extends to all the contributors whose articles have added depth and substance to this publication. I am equally grateful to the distinguished guests, participants, and students whose presence and active involvements have made this event truly meaningful. Your enthusiasm and support have transformed this occasion into a memorable celebration. To the dedicated IIAC staff, led by Mr. Vinay Sanduja, Registrar, IIAC, Ashish Padam, Council IIAC, Vikas, Bhagwat, Ravi, Mohit, Niharika, Kanika, Gayatri, thank you all for your behind-the-scene efforts that made this event a truly success. A special thank you to Mr. Himanshu, Council IIAC, for such a wonderful comparing of the event. Finally, I extend my gratitude to everyone who contributed directly or indirectly to the success of this event. Each one of you has played a vital role in making this day remarkable. As we conclude, let us carry forward the knowledge, inspiration, and positivity we have gained today, and continue to work with passion and purpose and make India a hub of international arbitration. Once again, thank you all for being part of this wonderful event. Thank you very much.
This concludes today's proceedings. We request the audience to remain seated until. Okay, sir. Okay, sir. I request all the faculty conveners and all the student conveners of Paryai, please come and have a photo with us, please. Thank you, everyone. We request the audience to remain seated until the dignitaries have exited the hall, after which you are warmly invited for a high tea. Thank you.